This video is criminal law, and we're specifically talking about defenses. Continuing on with defenses, this is the defense of impossibility, and really it's attendant to the teachings having to do with inchoate crimes specifically, and most often attempt crimes. So here's a little decision tree to figure out whether your problems actually implicates the impossibility defense or not, because not all inchoate or attempt crimes lend themselves to these arguments. First question is it a complete or incomplete attempt? I go over it in a different video, but essentially, is this one of those situations where you classify it as something where the defendant did everything they could, or they were just on the path to committing an offense, so therefore it's considered an attempt? If it's the first, if it's incomplete, then essentially that's the evaluation that's sort of known to most and what most of us think of when we think of attempt. You know, did they have the requisite specific intent to commit the underlying crime? You know, were we stacking up the aggregate actus reus, or as the Model Penal Code and other statutes put it, a substantial step in the direction of committing the crime with the requisite intent? That's the analysis, and you go over there and it has nothing to do with sort of an impossibility in most factual scenarios. If it's a complete attempt, you know, which is the minority of fact patterns that we get, but you know, the bar still likes them, and you know, we still hear some of these that come up. So you go to question number 2. And this, I like to sort of phrase it differently than you find in some case books. If the defendant described his activity and described what he intended to do for his crime, would it be a crime? And I think that separates out some of what's traditionally known as legal impossibility. So if the answer to this is yes, you know, what did you intend to do? One of the classic ones is you know, a pickpocket that finds an empty pocket. Okay, you know, so that would be a complete attempt. So you answered yes to question 1. And then if the defendant were to describe his intended crime before acting, would it be a crime? Yeah, I intended to steal out of the pocket of the other person on the train. So that would be a crime. If, let's say it's, you know, it's, you have a crime that's essentially a legal impossibility. I thought I was violating hunting season, and I was going hunting after April 1st, but it turns out it's, you know, it's April 3rd, but hunting season doesn't start until a week later. So what you thought you were doing, what you intended to do before acting, was not a crime. So therefore it's a legal impossibility. If you thought you were committing a crime, but you turned out to not be committing a crime, as described before you were acting, then it might be legal impossibility, which is a defense, which means there's no crime. If we proceed to 3, because it's a no to that question, you know, it's more like the pickpocket scenario, or, you know, if you intend to kill someone and you point a gun across and you shoot, it turns out to be a mannequin. Well, describe that activity before acting. I intended to kill that person that was over there. That would be a crime. That would be intentional murder. You had the specific intent to commit the underlying crime, and you acted. You did something. You did everything that you thought you could. And then this is the kind of final question that gets at factual impossibility, or what's sometimes called hybrid legal impossibility. Did the defendant do everything in his power to complete the crime, but some outside factor, some fact outside of his control, prevented completion? You know, and that's your typical factual impossibility scenario. And just try to keep straight, factual impossibility is not a defense. And this is what you see when you deal with undercover agents. You know, you might be meeting an undercover agent for a drug deal. Well, it wasn't possible. I wasn't going to get drugs from that undercover agent. They didn't have any. Or I wasn't going to be able to conspire with another person to commit this crime because the other person was an undercover agent. Nope. That's factual impossibility. The defendant, with the requisite intent to commit the underlying crime, did everything he could. And just because that person turned out not to be a dealer, just because that person turned out not to be a criminal, that prevented the completion. But that's outside of his control, and he had the requisite intent, and it's a complete attempt. Factual impossibility is no defense. You know, same thing with the pickpocket. They did everything they could. They went into the pocket. They had the intent to steal, specific intent to commit the underlying crime. They went all the way into the pocket. It just happened to be empty. Well, they did everything in their power to complete the crime. Some outside factor, something outside of their control, that is the pocket being empty, prevented it. And when you get these limited scenarios where, maybe the person didn't do everything in their power, or maybe they thought there was, they thought the scenario was different than they might have envisioned. There's a famous case that has to do with a dealer, a criminal dealing with an undercover agent, and actually brings non-controlled substances to the drop. And he said, I was intending to rip the guy off. I was intending to take his money and not give him drugs. So I was intending not to deal drugs. Well, then you might have a defense, or you might have a factual issue for the jury, because he didn't do everything in his power to commit the crime. But most oftentimes, impossibility is not a defense because it's some factual impossibility. It's just a guy talking online to what he believes to be a minor and saying inappropriate things and doing inappropriate things. Turns out to be some kind of agent or investigator on the other side. Well, yeah, you didn't have inappropriate conversations with a minor, but you had the requisite intent and you did everything within your power. It was just a factual impossibility to a complete attempt, and that's no defense, and it's typically going to be a crime. So try to keep straight these couple of questions. Is it complete or incomplete? Most of them are going to be incomplete, and you're just evaluating whether they've gone further enough with the requisite criminal intent, or this requisite specific intent to commit the underlying crime. I think if you ask the second question, you're going to root out most of the legal impossibility issues. If you had the defendant describe what he was doing at the front end, would it be a crime? Sometimes defendants are mistaken. They think they're going to commit a crime, but it's not a crime. That's legal impossibility. And lastly, if you want to separate out these factual impossibility questions, which most complete crimes lend themselves to some type of argument. No. I did everything I could, but I didn't commit this crime because of some fact outside of my control. That's factual impossibility. That's an argument that defendants make and defense counsel make on their behalf, but it's no defense to a complete attempt under most statutes in that common law.